A video on importance of witnesses. Hello everyone, I am Mr. PRIYANK GEETA GANESH CHUDASAMA, legal intern at ubAdvocate under the guidance of Shri Jeevan Prakash sir, who is an advocate on record in Supreme Court of India. Under the Indian Evidence Act 1872, Chapter 9 of the Witnesses. So the said chapter, that is of witnesses under the Indian Evidence Act 1872, starts with section 118, which states who may testify, यानी कि जो सेक्शन 118 है वो क्या बताता है कि हम लोग में से कौन जो है वो टेस्टिफाई कर सकता है. All the persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to those questions by tender years, extreme old age, disease, whether of body or of mind, or any other cause of same kind. यानी कि ये सेक्शन जो है 118 वो हम लोग को क्या बोलता है, कौन लोग टेस्टिफाई कर सकता है. हर एक पर्सन, एवरी पर्सन शाल बी कॉम्पिटेंट, यानी कि वो सभी कॉम्पिटेंट है टेस्टिफाई करने के लिए, अनलेस अगर कोई कोर्ट ने कंसिडर किया है कि उन लोगों को रोका जाए या उनको प्रिवेंट किया जाए अंडरस्टैंडिंग द क्वेश्चंस पुट टू देम. जो क्वेश्चंस उनके सामने पूछे गए हैं वो उनका जवाब नहीं दे सकते. क्यों नहीं दे सकते? फॉर गिविंग रैशनल आंसर अगर दे भी सकते तो पर परफेक्ट आंसर्स जो है कोर्ट को चाहिए वो नहीं दे पाएंगे. वो जो क्वेश्चंस इनके सामने दिए हुए हैं वो क्यों ऐसा हो सकता है, बाय द टेंडर ईयर्स, या फिर बहुत ही उनका एज हो चुका है वो पर्सन का, या फिर उनका जो कोई ऐसी डिजीज है जिनकी वजह से उनकी बॉडी या माइंड या कोई ऐसा तरीका जिसकी वजह से वो डिजीज की वजह से वो आंसर नहीं दे पाए, या कोई भी ऐसा प्रॉब्लम हो ऑफ द सेम काइंड जो उसकी वजह से वो टेस्टिफाई नहीं कर सकता. अनलेस, मतलब ये सेक्शन का मेन कहने का था कि हर एक पर्सन टेस्टिफाई कर सकता है अनलेस एंड अनटिल कोर्ट जो है तीन पॉसिबिलिटी चांसेस जो है वो देखेंगी, जाने की टेंडर ईयर्स, एक्सट्रीम ओल्ड एज, या कोई ऐसी टाइप की डिजीज है जिसकी वजह से वो रैशनल आंसर्स नहीं दे पाएगा. उसके लिए हम लोग को एक एक्सप्लेनेशन भी दिया गया है. लूनाटिक इज नॉट इनकॉम्पिटेंट टू टेस्टिफाई unless he is prevented by his lunacy or from understanding the questions put to him and giving the rational answers to them. तो ये जो सेक्शन है वो क्या बोलता है, a witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible as by way writing or by signs, but such writing must be written and the signs made in open court. The evidence so given shall be deemed to be the oral evidence. यानी कि वो witnesses जो बोल नहीं पाते हैं, who is unable to speak may give his evidence, वो evidence दे सकता है कोई भी दूसरे मैनर में जाकि वो इंटेलिजिबल हो सके. जैसे कि वो अगर वो लिख के दे सकता है, अगर उसे लिखना नहीं आता तो हम लोग साइन एक्सपर्ट को बुला के वो साइन से भी वो बता सकता है. बट सच राइटिंग अगर वो लिख के देते हैं मस्ट बी रिटर्न, और साइंस जो है वो ओपन कोर्ट के सामने होना चाहिए. तो ये एविडेंस जो वो रहेगा वो डीम्ड हो जाएगा टू बी एज एन ओरल एविडेंस. सेकेंड पॉइंट जो है वो क्या है, प्रोवाइडेड दैट इफ द विटनेस इज अनएबल टू कम्युनिकेट वर्बली. अगर समझो कि विटनेस जो है वो कम्युनिकेट वर्बली नहीं कर पाता है तो कोर्ट जो है वो असिस्टेंस ले सकती है. किसका? एक इंटरप्रेटर का ले सकती है या फिर स्पेशल एजुकेटर का ले सकती है जो रिकॉर्डिंग स्टेटमेंट में मदद कर सकता है, या फिर सच स्टेटमेंट जो भी रहेगा वो वीडियोग्राफ भी हो सकता है. So we are on section 120, which deals with parties to the civil suits and their wives or husbands. Husband or wife of a person under the criminal trial. मतलब जो सिविल सूट्स और क्रिमिनल ट्रायल है उनके रिलेटेड हमें ये बताया गया है. So in this section it states that in all civil proceedings the parties to the suit and the husband or wife of any party to the suit shall be competent witnesses. जाने की अगर कोई भी सिविल प्रोसीडिंग्स है तो पार्टीज जो रहेंगे सूट में, उसमें हस्बैंड हो या वाइफ हो या कोई भी पार्टी ऑफ एनी पार्टी जो हो सूट के अंदर, वो कॉम्पिटेंट है विटनेसेस के लिए. अगर समझो क्रिमिनल प्रोसीडिंग्स है तो उसके रिलेटेड क्या है, in the criminal proceedings against any person the husband or wife of such persons respectively shall be a competent witnesses. मतलब दोनों में ही वो competent witness बन सकते हैं. Next section is section 121 which deals with judges and magistrates. यानी कि उनके जो witnesses रहेंगे judges और magistrate के, उनके related बोला गया है. वो यहाँ पे बोला गया है नो जज और मैजिस्ट्रेट शाल except upon the special order of some court to which he is subordinate, be compelled to answer any questions as to his own conduct or in a court as a judge or a magistrate, or as to anything which came to his knowledge in court as a judge or a magistrate, but he may be examined as to other matters which occurred in his presence which he was so acting. हम लोग यहाँ पे अभी इलास्ट्रेशंस देखेंगे रिलेटेड टू सेक्शन 121 और समझो इलास्ट्रेशन नंबर 1 है A on his trial before the court of session says that the deposition was improperly taken by B जो कि magistrate है. The B cannot be compelled to answer questions as to his except upon the special order of a superior court. Okay. Second is illustration number B, यानी कि एक A जो accused before the court of session of having given false evidence before before B, जो कि magistrate है. B जो है उसको cannot be asked what he said except upon the special order of the superior court. Illustration number C देखेंगे. Illustration number C में जो है he is accused before the court of session of attempting to murder a police officer whilst on his trial before B, a session judge. B जो है वो examine कर सकता है as to what occurred. Now we are going further to section 122, which deals with the communications during marriage. State, it means no person who is or has been married shall be compelled to or disclose any communication made to him during marriage by any person to whom he is or has been married, nor shall be permitted to disclose any such communication unless the person who made it or his representative in the interest consents, except in the suits between the married persons or proceedings in suits between the married persons or proceedings in which one married person is prosecuted for any crime committed against the other. Further, it's section 123, which deals with the evidence as to affairs of the state. So section 123 जो है जो evidence related to है state of affairs जो है उसके related क्या बताया जा रहा है यहाँ पे no person or no one shall be permitted to give any evidence derived from unpublished official records relating to any affairs of state except with the permission of the officer at the head of department concerned, who shall give or withhold such permission as he thinks fit. Section is section 124, which is regarding the official communications. No public officer shall be compelled to disclose communications made to him in official confidence when he considers that the public interest would suffer by the disclosure. Section 125, which deals with the information as to the commission of offences. So no magistrate or a police officer shall be compelled to say when he got any information as to the commission of any offence, and no revenue officer shall be compelled to say when he got any information as to the commission of any offence against the public revenue. For this explanation has been given, that is, revenue officer in this section means any officer employed in or about the business of any branch of the public revenue. Section 126 deals with the professional communications. No barrister, attorney, pleader, or vakil shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in the course and for the purpose of his employment, has such barrister, a pleader, attorney, or vakil by or on behalf of his client, or to state the contents or the condition of any documents with which he has become acquainted in the courts and for the purpose of his professional employment, or to disclose any advice given by him to his clients in the courts and for the purpose of such employments. Further, it has been stated that provided that nothing in this section shall protect from disclosure. First point, any such communications made in the furtherance of any illegal purpose. Second point, any fact observed by any barrister, pleader, attorney, or vakil in the course of his employment has such showing that any crime or fraud has been committed since the commencement of his employment. It is immaterial whether the attention of such barrister, pleader, attorney, or vakil was or was not directed to such fact by or on behalf of his client. There is also an explanation given to this point. That is, the obligation stated in this section continues after the employment has ceased. For more clarifications, there are illustrations which will be referred. Illustration number A, a client says to be an attorney, I have committed forgery and I wish to defend me. As the defense of a man known to be guilty is not a criminal purpose, this communication is protected from disclosure. Illustration number 2 is, that is B, a client says to be an attorney, I wish to obtain possession of a property by the use of forged deed on which I request you to sue. This communication is being made in furtherance of a criminal purpose is not protected from disclosure. Illustration number C, a being charged with embezzlement retains B an attorney to defend him. In the course of proceedings, B observed that an entry has been made in A's account book charging A with the sum said to have been embezzled, which entry was not in the book at the commencement of his employment. Now, the illustration number A, B, and C, there's been a fact observed by B in the course of his employment showing that the fraud has been committed since the commencement of the proceedings. It is not protected from the disclosure. So here the section 126, that is regarding the professional communication, comes to an end. Section 127, which deals with section 126 to apply the interpreters. This section मतलब जो section 127 जो है वो section 126 के related ही है जो apply करेगा interpreters को भी. So the provisions जो है section 126 का वो apply करेगा interpreters को and the clerks और servants और barristers जो भी उनके baritors के related है, pleaders के related है, attorneys है या वकील से, उन सभी पे ये section applicable होगा. Section 128 जो है वो किसके related है? It's related to the privilege not waived by volunteering evidence. If any party to a suit gives evidence therein at his own instance or otherwise, he shall not be deemed to have consented thereby to such disclosure as is mentioned in the section 126. And if any party to a suit or proceedings calls any such barrister, pleader, attorney, or vakil as a witness, he shall be deemed to have consented to such disclosure only if he questions such barrister, attorney, or vakil on matters which, but for such questions he would not be at a liberty to disclose. Section 129 deals with the confidential communications with legal advisors. No one shall be compelled to disclose to the court any confidential communication which has taken place between him and his legal professional advisors, unless he offers himself as a witness, in which case he may be compelled to disclose any such communication as may appear to the court necessary to be known in order to explain any evidence which he has given, but not others. Section 130, production of title deeds of witness not a party. No witness who is not a party to a suit shall be compelled to produce his title deeds to any property or any document in virtue of which he holds any property as a pledge or mortgagee, or any document the production of which might tend to criminate him, unless he has agreed in writing to produce them with the person seeking the production of such deeds or some person through whom which he claims. Section 131, the production of documents or electronic records which another person having possession could refuse to produce. No one shall be compelled to produce documents in his possession or electronic records under his control, which any other person would be entitled to refuse to produce if they were in his possession or control, unless such a last mentioned person consents to their production. Section 132, that is, the witness not excused from answering on ground that answer will criminate. A witness shall not be excused from answering any question as to any matter relevant to the matter in issue in any suit or in any civil or criminal proceedings upon the ground that the answer to such questions will criminate or may tend directly or indirectly to criminate such witness, or that it will expose or tend directly or indirectly to expose such witness to a penalty or a forfeiture of any kind. Proviso there is available, that is provided that no such answer which a witness shall be compelled to give shall subject him to any arrest or a prosecution or be proved against him in any criminal proceeding except a prosecution for giving a false evidence by such answer. Section 133, which is regarding accomplice. Complies shall be a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of a complice. Section 134, that is number of witnesses. Section 134, that is number of witnesses, deals that no particular number of witnesses shall in any case be required for the proof of any fact. Thank you everyone for listening this video. Hopes you have liked this video. Please share it with others for this knowledgeable purpose and help the society at large.